Why evolving European SAR policies threaten merchant shipping? Operators of commercial vessels have rescued tens of thousands of migrant seafarers in the Mediterranean Sea since 2014. For commercial actors, swift disembarkation of survivors is critical to ensure safety and prevent further disruption to the rescuing vessel primary voyage. From 2014 through 2017, European coastal states such as Italy, Malta, and Greece permitted rescued migrants to disembark into their territory. But recent policy changes reflect evolving attitude about search and rescue or SAR responsibility. Beginning in 2018, commercial vessel and humanitarian non-governmental organizations or NGOs have performed large-scale rescues only to be denied immediate access to Mediterranean port. This has created alarming scenarios in which rescued migrants and ship operators have remained at sea for days and weeks as solutions were negotiated by politicians on an ad hoc basis. Addressing the consequences of this policy transformation, this paper examines its impact on commercial vessel contribution to migrant rescues. Highlighting the intertwined legal responsibilities of private vessels and public authorities, it discussed the international SAR framework and its contemporary implementation. It then surfaced reaction within the shipping industry, reflecting concern that evolving regional perspective may drive up the risk, cost, and frequency of private participation in SAR operation. Since 2014, more than 18,000 migrant seafarers have died attempting to cross the Mediterranean Sea to reach Europe. During this period, many tens of thousands of people have also been rescued by state coast guard, naval patrols, humanitarian NGOs, and commercial vessels. These rescuers have coordinated attempts to ensure that migrant vessels in distress situations are engaged as quickly as possible and that survivors are delivered to a place of safety in accordance with international legal obligations. During the initial months of this crisis, the rescue infrastructure was under immense strain to respond to the scale and regularity of distress situations. At that time, operators of commercial vessels often served as first responder for performing over 40,000 rescues in 2014, approximately 25% of the total rescues during that period. These private actors provided heroic contribution despite the enhanced risks and costs of using commercial equipment and personnel to effectuate large-scale rescues. In the years that followed, other rescuing actors assumed primary SAR responsibility, which relieved commercial actors of some of the rescue burden suffered in the initial months of the crisis. But even with the emergence of alternative rescue contribution, commercial vessels have remained an essential part of the Mediterranean SAR apparatus. For these commercial actors, swift disembarkation is critical to ensure the safety of those on board and to prevent extensive disruption to the rescuing vessel primary voyage. The infamous MV Tampa incident of 2001 served as an alarming flashpoint illustrating the potentially dangerous humanitarian consequences of delayed disembarkation as hundreds of rescued migrants were held on the deck of a container vessel for nearly 2 weeks after it was denied access to the nearby Australian port. In response to the Tampa incident, the international maritime community revisited the legal framework governing rescues at sea and amended international legal instrument articulating SAR obligation to ensure a safe place of disembarkation is quickly determined. Under this updated framework, disembarkation of rescued persons in the Mediterranean has been performed primarily in Italy, Greece, and Malta since 2014. But recent policy changes in Europe have reflected new attitudes about SAR obligation and disembarkation responsibility. Beginning in 2018, NGO and commercial vessels have performed rescues in the Mediterranean Sea only to be denied access to nearby port. This has created perilous situations in which rescued migrant and rescuing vessel operators have remained at sea for days and weeks, while ad hoc political solutions for disembarkation were negotiated on shore. Addressing this policy transformation regarding survivor disembarkation, this paper examined its impact on commercial vessel contribution to large-scale migrant rescues, highlighting the intertwined responsibilities of private vessels and public authorities. It discussed the legal framework codifying the obligation to render assistance and disembark rescued persons to a place of safety. It then surfaced reaction within the shipping industry, reflecting concern that evolving perspective in Europe may drive up the risk, cost, and frequency of private participation in SAR operations. Public and private SAR obligation. Under international law, several international legal instruments codify SAR obligation attached to public and private maritime actors. This agreement reflects a centuries-old customary duty to assist vessels in distress. The United Nations Convention on the Law of the Sea or UNCLOS, the Safety of Life at Sea Convention or SOLAS, the International Convention on Salvage, and the International Convention on Maritime Search and Rescue or SAR, each contribute to the modern framework allocating responsibility and compelling coordination in maritime distress situations. This instrument placed distinct obligation on coastal state and private shipmaster in attempts to ensure that persons in distress at sea will receive assistance and be delivered to a place of safety. Contracting state to UNCLOS are required to promote the establishment, operation, and maintenance of an adequate and effective search and rescue service regarding safety on and over the sea, in coordination with neighboring coastal states. The SAR Convention goes further by obliging states to apportion their collective search and rescue responsibilities. Operationalizing this obligation, states have divided the ocean into designated SAR regions and have established Rescue Coordination Center or RCCs at strategic locations around the world. These RCCs monitor distress signal, coordinate communication between distress vessels and rescuing actors, and organize the provision of emergency medical services. RCCs train and deploy state search and rescue units, but they also regularly call on ships already operating at sea, including private commercial vessels, to contribute whenever necessary. Both the SOLAS Convention and the Salvage Convention explicitly require private shipmaster to assist persons in distress at sea. The SOLAS Convention reads at the relevant part, the master of a ship at sea, which is in a position to be able to provide assistance on receiving information from any source that persons are in distress at sea, is bound to proceed with all speed to their assistance. The Salvage Convention contained a similar provision, which reads, "Every master is bound, so far as he can do so without serious danger to his vessel and person thereon, to render assistance to any person in danger of being lost at sea." Thank you.